90 homes, one Henderson community, and they're sinking. Not settling the way every house settles a little over time, sinking, with cracks running through walls, patios pulling away from the house, doors that won't close right anymore. We have a lot to talk about today, so let's get right into it.
I'm Cruzette Hydron. I've lived in Las Vegas for over 40 years. Welcome to my channel, where local insight meets real guidance.
Hey guys, I'm Cruzette. I live, work, and play right here in Lake Las Vegas, and I genuinely care about this community and the people in it. So every week I break down what's actually happening in this market and pass it straight to you. Before we get into it, this is part one of a two-part series because there's genuinely too much here to cover honestly in just one video. I actually first touched on this back on March 25th on a video called The Good, the Bad, and the Ugly about moving to Henderson, Nevada. The response to that video was huge, especially around the structural issues and construction defects happening at Del Webb. So many of you had questions that I decided this topic deserved its own dedicated, in-depth series. I'll link that original video in the description if you want to go back and watch it. Today in part one, we're covering the Del Webb lawsuit against Pulte, the actual Nevada law that governs it, the court's arbitration ruling from May 13th, straight from the case file with the judge's own reasoning, and a fresh update on where the community stands right now, including how many homes are currently on the market and how many have actually sold. Part two drops next week, a major new Fannie Mae lending rule, and what everything we cover across both videos means whether you're selling, buying, or already living in a community like this. By the end of part one, you'll understand your rights as a Nevada homeowner, exactly how this legal fight got to where it is today, and what's really happening in this community right now. Let's start with Del Webb Lake Las Vegas. This is a 55-plus master planned community, and the homes here aren't cheap. We're talking some of the homes are well over $1 million for a lot of these properties. So the Del Webb Lake Las Vegas Community Association, that's the HOA, filed a lawsuit against Pulte Homes of Nevada, which is a subsidiary of Pulte Group. That's the builder behind this whole community. The claim, nearly 90 homes in the community are showing damage that homeowners say traces back to how the site was built. We're talking cracked walls, patios separating from the house, gap door thresholds, bowed walls, and uneven floors. And some homeowners describe them as tripping hazards. A lot of the visible damage is concentrated near the large retaining walls on the property. The lawsuit alleges the builder graded steep, rocky, alluvial fan terrain, which are the canyons and hillsides, and that the soil underneath these homes wasn't properly compacted before construction. In plain terms, homeowners are saying the ground underneath their homes was never stable enough to build on the way it was built. This isn't a one homeowner complaint. This is the HOA itself, suing on behalf of dozens of residents. And the number of homeowners involved has continued to grow as more of them have come forward. Attorney Norberto Cisneros, who represents a number of these homeowners, says that as of the most recent reporting, roughly 50 homeowners were actively part of the suit. And that number keeps climbing as more residents reach out to him. Now, to be fair, the other side of this, Pulte's spokesperson, Ali Boyle, says repairs are already complete or underway for 43 of these homeowners. That's under 5% of the community, and that an independent third-party engineer confirmed the retaining and rockery walls are performing consistent with their original design specifications. Now, here's something most homeowners don't know until they actually need it. In Nevada, you can't just sue a builder the moment you find a crack in the wall. Nevada Revised Statutes Chapter 40, most people in the industry call it Chapter 40, is a mandatory process that has to happen before any residential construction defect can go to court. It applies to individual homeowners and it applies to the HOAs. And Del Webb's HOA had to go through this exact process before this case ever became a lawsuit. It works in 4 steps, in order. Step 1, warranty exhaustion. Before anything else, the homeowner has to actually pursue repairs through the builder's standard warranty. Step 2 is the notice of defect. If the warranty doesn't fix it, the homeowner or HOA has to send the builder a detailed, signed written notice by certified mail laying out the specific structural, cosmetic, or system defects. Step 3, the right to inspect and cure. The builder gets a set window of time to physically come inspect the property. And after that, they have what's called the right to cure, meaning they can offer repairs, offer money, or simply deny the claim. Step 4 is mandatory mediation. If the homeowner turns down the builder's offer or the builder denies responsibility altogether, both sides are required to sit down with an independent mediator before this can move to a court, or, as we'll get into it, an arbitrator. So what actually counts as a defect under this law? Well, under NRS 40.615, a constructional defect is anything in the design, building, or landscaping that violates a building code, causes actual physical damage like a shifting foundation, fails to meet accepted workmanship standards, or creates an unreasonable safety risk for the people living there. There are also hard deadlines. A homeowner has an absolute outside limit of 10 years from the date the home was completed to discover and bring a claim. That's called the statute of repose. And once a specific defect is actually discovered, the clock on formally starting the Chapter 40 process for that issue typically runs 3 to 4 years. Okay, now here's the piece that connects directly back to Del Webb. Nevada law gives HOAs the standing to bring Chapter 40 claims for defects in common areas like clubhouses, shared structural components, anything the association is responsible for maintaining or insuring. The retaining walls in this case are exactly that kind of shared structural component. That's the legal basis that allowed the Del Webb HOA to step in and sue on behalf of the whole community, not just the individual homeowners. So the HOA did everything Chapter 40 required: warranty, notice, inspection, mediation. And when that didn't resolve it, the next question became, does this go to a jury in open court or does it go to a private arbitrator? Pulte, named in the court file as PN2 Inc., argued arbitration was required based on agreements tied to the original home purchase contracts and the HOA's governing documents. A Clark County judge heard arguments on that question on March 30th. On May 13th, Judge Mark Denton issued his ruling. The court granted Pulte's motion to compel arbitration, denied the homeowner's request to hold that motion off pending further discovery, and stayed all further proceedings in the case pending arbitration. Here's what's worth knowing about how the judge got there. Homeowners' attorneys raised several legal arguments for why this dispute shouldn't be forced into arbitration, including that the clause itself was unfair. The judge wasn't persuaded and pointed to existing Nevada law that generally favors enforcing arbitration clauses like this one when a builder moves promptly to invoke them. One more detail worth knowing: the judge didn't award Pulte its attorney's fees, even though Pulte won, saying the homeowners weren't wrong to raise the arguments they did. So this was a real procedural win for Pulte, but the court didn't exactly slam the door on the homeowners either. Now, this isn't unique to Del Webb. Binding arbitration clauses like this are standard practice across Pulte Group's home purchase contracts. And it's worth understanding what you actually sign away when a clause like this is buried in your paperwork, because it applies well beyond one lawsuit. First, you lose access to public court. Even when dozens of neighbors report the exact same foundation or structural problems, a judge will typically enforce that clause and push everyone into individual arbitration. Second, most of these contracts include a class action waiver. That means homeowners can't band together and pool resources to hire the kind of expensive geotechnical and structural experts a case like this actually needs. Everyone fights alone against a multi-billion-dollar builder. Third, arbitration is confidential. In open court, transcripts, expert witness reports, and soil testing results become part of the public record. In arbitration, none of that becomes public, which means future buyers looking at that community have no way of finding out about a widespread defect pattern before they sign a contract of their own. Fourth, your appeal rights are extremely limited. In court, a flawed ruling can be appealed. In binding arbitration, the arbitrator's decision is essentially final, even if they got a fact or building code wrong. And fifth, this one surprises people: arbitration isn't free. Homeowners are often required to cover half of the arbitrator's hourly rate, and those rates commonly run $400 to $800 an hour. For an individual homeowner going up against a national builder, that's a real financial barrier before the case is even decided. So how does this connect back to Chapter 40? Even with a binding arbitration clause in the contract, the homeowners still have to complete the full Chapter 40 pre-litigation process first: the notice, the inspection, the cure period, and the mediation. Chapter 40 doesn't go away just because there's an arbitration clause. What changes is what happens after mediation fails. Instead of the next step being a lawsuit in Nevada District Court, the purchase contract redirects the next step into private arbitration. That's exactly the sequence that's played out here. Chapter 40 got this case to the table. The purchase contract determined where it goes from there. So what's happening on the ground now? Everything I've covered so far comes from public reporting and from actual court files. Case number A-25-934238-B, if you want to look it up yourself. But I also stay in close contact with people who live in this community, and what they're describing right now is worth sharing too. I want to be upfront about this part. It comes from residents on the ground, not from a published article or a court filing. I'm going to be clear about what's confirmed and what's being reported to me. According to residents I've spoken with, an engineering firm has installed ground movement meters on the hillside, monitoring how the soil and the rock retaining walls are actually shifting over time. Most of that monitoring is concentrated on one street in particular, but residents say other streets are showing rock wall movement too, and a couple of homes have reported new cracking in their backyards. In at least one case, a crack that ran through the pool itself and drained it. On the legal side, it's bigger than just the HOA's lawsuit. I'm told there are now 3 separate law firms working with somewhere between 50 and 70 individual homeowners who filed their own Chapter 40 claims, separate from the HOA's case, and covering both their individual homes and the shared common property attached to them. The HOA's own claim over the common areas, the retaining walls, the clubhouse, is estimated at $50 million to repair, mostly because of what it would cost if those rock walls would actually fail. And now there's a new piece, the money part. A special assessment is reportedly being discussed within the community, with early figures as high as $50,000 per household. I've seen this number myself in a recent HOA communication sent to homeowners that specifically raised the possibility of an assessment at that level. Here's a dynamic some residents point to for why the number could land that high. If repairs to the common areas run around $50 million, and the attorneys representing the HOA are working on its contingency fee, commonly reported around 40% of that recovery, that's roughly $20 million that has to come from somewhere. Because this is now headed to arbitration instead of a straightforward settlement, some in the community believe a special assessment may be the only way to cover that gap. And I want to be clear, I haven't independently verified the exact fee arrangement, and the HOA hasn't finalized any assessment number, but it's clearly part of the conversation happening in this community right now, which is exactly why it matters if you own or are thinking about buying a home there. And it's not only a common area problem. For the 50+ individual homeowners in their own Chapter 40 claims, some are reportedly facing repair costs approaching $500,000 on their own home, plus attorney fees on that individual claim, commonly cited around 35%, on top of whatever special assessment eventually comes down for these shared repairs. That's 2 bills, not one. I've also heard that at least a couple of residents have already made the difficult decision to walk away entirely, taking a reverse mortgage to pull out whatever equity they can, moving out, and letting the HOA eventually take the property back through a lien once they stop paying dues. I'm sharing that not to be dramatic, but because it tells you how real the financial pressure has become for some homeowners in this situation. So let's talk numbers on the market itself, because that question comes up constantly. How many homes here are actually for sale right now, and how many are actually selling? From what I'm seeing and hearing, more than a number of homes in this community are currently on the market. I recently looked at the MLS, and there are more than a couple of handfuls of homes that are currently on the market. The ones that are actually selling are mostly at the lower end of the price range, and most of those sellers are taking real losses compared to what they had gotten before any of this became public. Buyers agents are increasingly aware of this special assessment conversation, and it's showing up directly in offers. A couple of homes have still sold at higher price points, but in those cases, it's worth wondering whether the buyer did full due diligence of what they were walking into. So here's where things stand at the end of part 1. The Webb lawsuit against Pulte followed Nevada's Chapter 40 process exactly as the law requires, and on May 13th, the court ordered it into private arbitration instead of a jury trial. Beyond the HOA's own claim, dozens of individual homeowners are now pursuing their own Chapter 40 cases, and there's real talk in the community of a special assessment that could run into the tens of thousands of dollars per household, all while homes are already listing and mostly selling at a discount. In part 2, we're covering a major new Fannie Mae lending rule that takes effect in a matter of weeks, and what everything we've talked about across both videos actually means for you, whether you're selling a home in a community like this right now, thinking about buying into one, or you already live in one and want to know what to watch out for. Part 2 goes live next Wednesday. Please hit subscribe and turn on your notifications so you don't miss it. This is exactly the kind of story that keeps evolving, and I'll keep tracking it for you. If you're thinking about making a move up, down, or across Henderson or Lake Las Vegas, and you want someone who's actually tracking what's happening in these communities, that's what I'm here for. Reach out, the link's below, and that's it for now. There's more to uncover next week. I'll see you in part 2.